Welcome to SCO's daily updates. The Supreme Court proceeded with day 4 in the petitioner's arguments in the plea for marriage equality for the queer community. Notably, Justices S.K. Kaul and S. Ravindra Bhatt, due to personal illnesses, were unable to physically attend the hearing. Therefore, they attended these hearings virtually. 5 senior advocates presented arguments for the petitioners today. Commencing arguments for the day, Senior Advocate Geeta Luthra argued for her petitioners in the context of the Foreign Marriage Act. She stated that the Foreign Marriage Act allows Indian citizens, or at least one Indian person, to marry a person of their choice under valid marriage laws abroad. And as long as this marriage is validly registered abroad, it will also be registered in India. However, Ms. Luthra presented a conundrum. She stated that her petitioners, who were a same-sex couple who married in the state of Texas in the United States, had a valid marriage in the United States. However, when they returned to India, their marriage is not recognized by Indian law, and in the eyes of the law, they returned to the status of strangers. Next, Senior Advocate Anand Grover argued on behalf of the transgender community. He highlighted the British influence in shaping today's perception of the transgender community, saying that the fact that there exists a derogatory view of the community by the society at large is because of British influence. He highlighted Indian history, where he said different communities, not just the Hindus, but the Buddhists and the Jains as well, have long recognized the transgender community in India and have accorded them with their due respect. In fact, he also, to highlight the progressive thinking that has been available in India since that has been present in India since centuries, he pointed out the different kinds of perceptions of transgender persons. For example, he pointed out that Hindu and Buddhist communities since centuries have viewed gender as an expression of physical characteristics, while the Jains have also considered a psychiatric basis for understanding genders. This, he argued, shows how progressive Indian society was long before Western influence even came into play. He also pointed out certain other intricacies or other complications that arise in law due to the present legal system. For example, he said that the law recognizes marriage between a cis male and a cis female in India. However, once this marriage has been registered in India, supposing one of the persons in the marriage decides to change their gender, the law would still recognize this marriage as valid. However, there is no law governing this sort of relationship, or would not allow any other transgender persons to arrive at the same status of relationship without first starting off as cis male and female couples. Next, Senior Advocate Jaina Kothari presented a very unique prayer before the court. While arguing on behalf of the transgender community and a transgender petitioner, Ms. Kothari asked the court to not just recognize the right to marriage equality, but also as an extension the right to family. She said that family plays a very core part of an individual's life. For example, she highlighted the COVID-19 pandemic, where everyone returned home for lockdown. She said that in cases, in such an instance, the transgender community especially suffered because when they went home, they often faced violence from their families. Transgender persons, she furthered, often face violence from their immediate natal families and not just from society as a whole, with the majority of the instances of violence and threats coming from their parents and siblings. To strengthen her argument on the right to family, Ms. Kothari pointed out to the International Covenant on Civil and Political Rights, the United Nations Declaration of Human Rights, the European Declaration of Human Rights, and the Yogyakarta Principles. All of these, she argued, recognize the right to family and the right to sexual identity and the right to sexual orientation. Her arguments were further strengthened by Senior Advocate Rinda Grover, who stated that one category of petitioners that she was representing had to necessarily be anonymized just due to the nature of threats to their life. Ms. Grover pointed out also that transgender persons have this concept called chosen family. Considering that most of the danger that they face comes from their natal families, transgender persons tend to form close-knit groups that function as their family even though they are not related by blood. She said that there needs to be a legal recognition granted to their chosen families so that in matters of succession or in cases where legal representative might have to make crucial medical decisions, that these decisions be made by a person that the transgender person trusts and has chosen, and not just someone who may be related to them by blood but does not have their best interests at heart. She also argued that recognizing marriage in these instances is also essential, as a legally recognized marriage also acts as a shield against any potential crimes that may act against them. Ms. Menaka Guruswamy also argued in favor of marriage equality today. She argued that the Indian Parliament, unlike the UK Parliament, is a constrained parliament. What she meant, she explained her argument by saying that the Indian Parliament is constrained by the Constitution of India, and therefore, since the Supreme Court is the interpreter of the Constitution of India, the Supreme Court has a right to make law, a right to grant this, is entitled to grant the right to marriage equality. The Chief Justice of India, D.Y. Chandrachud, pointed out that it is undisputed by all parties that under the Constitution, regulations made on personal laws are fully within the purview of the Parliament. So where does the Supreme Court fit in such a case? Justice S.R. Bhatt also pointed out the practical implications of granting a decision in favor of marriage equality for the queer community. He gave the example of a same-sex female relationship where if one partner dies intestate or without a registered will, in case of the Special Marriage Act as it exists until now, supposing such a situation arises before a heterosexual couple, the rights of the individual person would devolve back to their own personal laws. Like, for example, if the partners are Hindu and there is no provision under the Special Marriage Act, that partner's family under the Hindu Marriage Act would still be able to inherit property. In this instance, in the case of a same-sex female marriage, there is no recognition of two female partners in a relationship in the Hindu law, creating a vacuum in law. Justice Bhatt pointed out that the Supreme Court will not just have to make a declaration that there is a right to marriage equality, but will also have to consider the practical implications of these decisions. If not, the court will just be faced with multiple litigations until the issue is solved in the future. Ms. Guruswamy pointed out that at least this first step must be taken and the rest will follow. Ms. Guruswamy will present the rest of her arguments through a written note to the bench. However, these questions that went answered during Ms. Guruswamy's arguments were perhaps answered by senior advocate Saurav Kripal. Mr. Kripal pointed out that there exists a set of rights that are granted to the heterosexual community, specifically in this instance, the right to marriage. He said that there was no basis whatsoever to grant the heterosexual community this set of rights, while at the same time excluding the homosexual and the queer community from the same. He pointed out that just saying that certain practical difficulties would prevent the court from granting this right meant that legislative draftsmanship or parliament at any point could draft a law in such a way that is just that allows them to violate fundamental rights while making it impractical to correct the situation. In such a case, Parliament might by design would be empowered to violate the fundamental rights of citizens, and the courts would not be able to do anything just because it's impractical. He also pointed out a counter narrative saying that only heterosexual couples have a right to marriage under the Special Marriage Act effectively means that the Special Marriage Act is explicitly excluding the queer community. To elaborate, he said, the right to marriage under the Special Marriage Act would effectively read as you will have or a couple will have the right to get married as long as you do not belong to the homosexual community, which by itself is an explicit exclusion of fundamental rights that is unjustified in law. The petitioners will resume their arguments tomorrow. The bench has granted them 45 minutes to conclude their arguments, considering that 4 days have passed. Following the petitioners, the union government is expected to present their arguments opposing the right to equal marriage to the queer community. Stay tuned to SE Observer's website for more information on the background of the case and detailed hearing reports from every day. Thank you.